Listen, Miss Pugh, don't speak over me. Miss Pugh, just because you say respectfully does not mean that you get to interrupt me. That's disrespectful, right? Hang on. Listen, Miss Pugh, stop talking over me. If you want to stop talking over me.
Where is the verified claim that is being placed against my trust?
You can go back with the bailiff. Go back with the bailiff. Get your own attorney or represent yourself if you don't like it.
All right, guys. Today's courtroom drama is on another level. We've got a no-nonsense judge going head-to-head with a so-called sovereign citizen who clearly thinks she cracked the legal system. She walks in holding a tiny piece of paper, the classic sovereign script, like she's about to drop some kind of courtroom mic drop and walk out untouched. But let's be real, that's not how this works. She honestly believed a few rehearsed lines were enough to outsmart a seasoned judge. A confidence? Sure. Reality? Not so much. This hearing gets heated fast, and you can literally feel the tension building with every response. What do you think? Bold move or total meltdown waiting to happen? Let's dive in and watch how this courtroom showdown unfolds.
Good morning. Are you Janetta Pugh?
I am the beneficiary of that estate.
You're the what?
I am the beneficiary of that estate.
You're the beneficiary of what estate? Answer my questions, please, ma'am. I'm just trying to understand.
Beneficiary of that estate.
Okay.
For the record, I recognize Ms. Pugh. She's been here before.
I do as well, for the record.
And I looked into Mr. Christopher Wiley. I can't find that person as a practicing lawyer in the state bar page, and I have not been contacted by anybody on Ms. Pugh's behalf.
All right. So, Ms. Pugh, Mr. Lewis has been appointed to represent you at this point. Obviously, you know as well as anyone that you're in custody and we want to get your case taken care of. If you've hired or your family has hired another lawyer, then they have to contact the court so that we can do something with your case. And do you know if they've hired someone?
Respectfully, Your Honor, I do not agree with your appointed foreign agents, considering that the first duty is to the state and will be considered conflict of interest. You know.
Okay, so if you don't want, the only thing I can do, I'm appointing an attorney to you to help you, right? So if you don't want a court-appointed attorney, then your only option, two things. One is to represent yourself or to hire a lawyer. So if you don't like the way it works, then you do something different. So are you, listen to what I'm saying. Are you either going to represent yourself, or are you going to let Mr. Lewis represent you, or are you going to hire someone?
Objection, Your Honor. Respectfully, is this a court of record?
It is a court of record. So your objection's overruled.
Okay. Respectfully, Your Honor, where is the verified claim that is being placed against my trust?
It's right here. It's called an indictment. And Mr. Lewis has a copy of it, and he can show it to you. So that would be the verified claim against you.
Okay. Your Honor, respectfully, Your Honor, there were writs that was filed to the case that still haven't been received.
I've received your petition for writ of habeas corpus, and it's denied.
Okay. Respectfully, Your Honor, I demand to be released due to lack of evidence of stated claim and not being given the proper opportunity to obtain proper counsel to effective defense.
It's overruled.
Okay.
You're running out, aren't you?
No, it's fine.
No, it's really not fine. At this point, she's honestly not helping herself, and everyone in the room can see it. I've got to say, though, the judge's attitude here is impressive. She's just sitting there calmly, letting the argument play out, almost like she knows exactly how it's going to end. She's patient, composed, and just waiting for the script to run out of momentum. And that's what makes it so interesting. These arguments always come in with confidence, like someone believes they've discovered a hidden legal loophole. But the reality is, courts have addressed these claims time and time again. Simply saying I don't consent doesn't make charges disappear. That's not how jurisdiction works. What really stands out here is the contrast. She seems polite. She's saying, Your Honor. She's trying to sound respectful, but at the same time, it's clear she's relying on something that just isn't going to hold up. It feels less like defiance and more like someone who genuinely believes the strategy will work. And that's the part one don't fully understand. How does someone get to this point? What convinces a person that this approach is going to succeed in a real courtroom? It's one thing to read about these ideas online. It's another thing entirely to stand in front of a judge and try to argue them. What do you guys think? Is she fully convinced this works, or is she just hoping something sticks? Let's jump back in, because this hearing isn't over yet. Balance scale.
So here's the thing, Miss Pugh. I appreciate your position, but listen,
Respectfully, Your Honor,
Miss Pugh,
with
don't
my
speak over me.
incarceration, respectfully, Your Honor, with my incarceration being
Miss
solved-
Pugh, just because you say respectfully does not mean that you get to interrupt me. That's disrespectful, right? Hang on. Listen to me. Everything you have there is overruled. And here's one of the reasons why is because you have a lawyer. And your lawyer will file the appropriate motion. You're interrupting me again, which is disrespectful. So I'm going to leave Mr. Lewis as your attorney unless you choose to represent yourself or hire someone else. I'm going to give you 2 weeks to determine what you're going to do. You can go back. You can go back with the bailiff.
I will not agree or comply to your appointed
Go back.
agents.
You already said that, and that's overruled.
Duty is to the state.
Go back with the bailiff. Get your own attorney or represent yourself if you don't like it.
Yeah, that was definitely awkward. But hold on, this story isn't finished yet. She actually comes back to court on a later date, and don't worry, I've got that hearing covered too. So if you thought this was the peak, just wait. At this point, though, you really have to acknowledge the judge's patience. Handling arguments like this over and over again takes serious composure. She stays calm, listens carefully, and tries to make sense of points that have already been addressed countless times in courtrooms across the country. She's firm when she needs to be, a little sharp at times, but still professional. That balance is tough, especially when the same claims keep circling back. Personally, I think she's managing it pretty well. She's keeping control of the courtroom without completely losing her cool. But I'm curious, what do you think so far? Is she handling it the right way? All right, let's move on to the next hearing and see if things escalate even more from here. Because something tells me this isn't cooling down anytime soon. Fire balance scale.
Perfect. So, Miss Pugh, Mr. Jeffries has been appointed to represent you. He's trying to get caught up real quickly on all the information and the discovery in your case. I'm going to reset your case so that he can get all of that. Once he gets it, he'll be out there to go over it with you, and we'll see if we can get an announcement at the next court date.
Respectfully, Your Honor, I do not agree to comply with any of the appointed court agents, considering that their first duty is to the state.
I understand. We've had this conversation before.
And for your record, I'll be representing myself.
So if you want to represent yourself, there's some things. Ms. Pugh, stop talking over me. If you want to stop talking over me, if you want to represent yourself, then there is a process that we have to go through, and we'll do that today. If that's what you want to do, we'll get your case set for trial and we'll go forward that way. It is highly inadvisable for you to represent yourself. Lawyers have many, many years of training. They understand the law. They understand how a trial works, because here's what happens. When you're in a trial and you represent yourself, you're expected to know and follow all of the rules of evidence, all the rules of procedure. And so you're really at a disadvantage if you don't know those things. And so you have to do everything just like the assistant district attorney would. And if you don't, you're going to be in front of a jury and it's going to show, and it's just not going to be, it usually does not work out in your benefit. But I have to go through with you some questions first before we do that. And then if you still want to do that, then there's a couple of things couple of options, and we'll go over those as well. Okay. So I am supposed to ask you, I'm going to go through these questions. I need you to answer them if you want to represent yourself, because this is required. All right. So have you ever studied the law? Okay. Have you ever represented yourself before in any kind of criminal matter? Okay. Do you understand the charges against you?
I know we've been accused of.
Okay. And so do you know, and we've gone over before, I think, what the range of punishment is if you're found guilty on a jury? Do you know what that is? Let's see. Hold on a second. Let me pull you up here. We'll go over that again as well. The date of that allegations from June 22nd of 2021. And what that means is if you're found guilty, that the range of punishment that the jury could give you is between 2 years as a minimum punishment up to 10 years in prison, anywhere in between. Do you understand? And you answer out loud just for the record.
Do I understand? No, I don't understand.
What do you not understand about that?
I'm not even going to lie. I called that line before she even said it. At this point, after watching so many of these hearings, you can almost predict how the argument is going to unfold. When you break these cases down every day, you start recognizing the same patterns. The confidence is always there, but the legal support behind it usually isn't. On a serious note, though, situations like this can be frustrating to watch. Courtrooms operate with limited time and resources, and when arguments that have already been addressed by higher courts keep resurfacing, it stretches those resources even further. That affects everyone involved. I also noticed she didn't bring the small script we saw earlier. Maybe she memorized it, or maybe she decided to try a different approach this time. Either way, the stakes here are much higher now. If she chooses to represent herself in a case with serious potential consequences, that's a major risk. Without proper legal strategy, things can escalate quickly, and in situations like this, penalties could be severe. So let's jump back in and see what she decides. Is she going to double down on this approach, or reconsider before it's too late? Because if she goes all in on representing herself, this could take a very serious turn. Balance scale fire.
I don't understand, Your Honor.
So here's the thing. If you want to represent yourself, by law, you have to be able to understand these things. Otherwise, I've got to appoint an attorney for you. So you can't just say, I want to represent myself because I don't like the attorney or I don't like the process. This is the process that you're in. You live in Texas, you live in the United States. This is the law that applies to your case. So what do you not understand about the range of punishment if you're found guilty? And I'd be glad to explain it.
I don't understand because I haven't did anything wrong.
That's what a jury's for, right? And so if you say you're not guilty, then you go in front of a jury and they determine after they listen to the evidence if you're guilty or not. That doesn't have anything to do with if they find you guilty, you understanding that they could send you to prison for between 2 years and up to 10 years. Do you understand that part? What are you, yes or no? No, you don't understand that. So, Ms. Pugh, it's my understanding, I'm not going to allow you to represent yourself because you don't understand the law and the process. So we're on question number 4 out of 15 that I'm supposed to ask you. So Mr. Jeffries is going to stay on your case. I don't care what you want at this point. You can't do it. All right, you can go back with the bailiff. I'm done. Go back with the bailiff. Go back with the bailiff. Welcome to the criminal appointment list.
Yeah, fun, Judge.
This was not meant to be any kind of punishment, I promise. So Mr. Jeffries, get ready like you would. Probably it's going to go straight onto a jury, and we'll just get it figured out that way.
Honestly, I'd give this judge a 10 out of 10. Tell me if I'm wrong, but from what I saw, she did everything she could to make sure the hearing was fair before finally bringing it to an end. The patience she showed was seriously impressive. A lot of people would have lost their composure much earlier, but she stayed calm, controlled, and professional the entire time. That's not easy in a situation like this. At the same time, it's a little tough to watch. She clearly gave this woman multiple chances to explain herself and clarify her position. But if you've seen hearings like this before, you could already sense where it was heading. And to everyone watching, if parts of this made your head spin, you're not alone. These arguments can be repetitive and hard to follow. There's this mix of secondhand embarrassment and pure courtroom drama that somehow keeps you glued to the screen. You could almost see her thinking through every response, trying to find something that would land, but in the end, it just didn't connect. The strategy simply wasn't working.